Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode.
And friends, welcome back. We're once again in Callaway County down here in Murray, Kentucky with Social Security disability attorney Jeff Roberts. Jeff, how are you?
I'm doing good, Jim. How are you?
Buddy, I'm doing fine. Hey, we're going to talk a little bit about an issue that's kind of been happening in Social Security disability hearings. And we've got kind of a shortage of judges, and that may actually impact how the clients get their hearings done. Is that correct?
True. Paducah has had at one time, they had, I think, 5, maybe 6 judges over at Paducah.
And even if I'm not in Paducah, though, that's probably where my Social Security disability hearing would take place. Is that right?
Yes, in Western Kentucky, as a general rule, that's where the hearings were. Obviously, if you're in Tennessee, then they don't go to Kentucky. They go to a Tennessee office, Nashville, or somewhere else, depending on your location.
Right.
Paducah still has a hearing site, but they've gone down in the number of judges over the years there. And the last hearing I had in Paducah, the judge then told me that, because as we've talked about before, I do all of my Social Security hearings in person. I prefer that. I think it's better for my clients. I have much better results with in-person hearings over video conference hearings or telephonic hearings. And when I was talking to the judge afterwards, I'd said something, I made a comment, or he made a comment about the hearings, and I told him then, I said, well, I just do in-person. He said, well, you're going to see a lot of me because I'm the only one doing in-person hearings anymore. Wow. They had some judges that were associated with Paducah that actually had moved, but they were still covering Paducah cases for video conference hearings. But then earlier this year, I started getting my cases that were set for Paducah transferred to other hearing sites. And Evansville is one that I've had 3 hearings in Evansville now, in-person hearings up at the Evansville hearing site in Indiana. Some have been transferred down to Tennessee as well. And so I think that a lot of the Western Kentucky, the judge at Evansville, when I was talking to him after one of the hearings, he made the comment that there weren't any judges at the Paducah hearing site anymore. So that judge that I had late last year, and I knew he'd been talking about retiring for a while, but he apparently has made the decision to go ahead and retire. So he is no longer at the Paducah hearing site. So they, when we file, that's kind of where they initially go, and they still have the workers there, as far as I know, working the files up for the judges. But then when it gets time to the hearing, I think they're transferring them to the other hearing sites. If it's an in-person hearing, if it's not an in-person hearing, then the judge didn't have to be at the Paducah site anyway. The judge could be in Chicago and have a video conference hearing.
Okay. So. And just from a baseline, you mentioned, okay, if I'm in Western Kentucky, suddenly I'm going to Evansville, or I may be going down to Tennessee somewhere. That's because Social Security disability isn't state-based. It's federal, right?
Correct. It is federal. As we mentioned before, I am licensed in Kentucky to practice law. I'm not licensed in Tennessee. I'm not licensed in Indiana, but Social Security Administration has licensed me to practice before the Social Security Administration in all 50 states. So I'm allowed to practice in all 50 states, still waiting for Hawaii.
Still waiting.
But that is, so I can handle a Social Security case before the Social Security Administration in any state in the union, and have in numerous states before. I at some point I'd counted it up. I think it's like
7 or 8, isn't it?
Yeah, it's around that 7, 8, 9, somewhere in that neighborhood of states that I have handled cases in that regard. And so, but this is going to create some issue for me. I've got to do a little research, but luckily on the 3 hearings I've had up there, I've won all 3 of those. But the appeal is to federal court.
Oh.
And so if I'm appealing from Evansville, I've got to do some checking to see if the appeal is based on where the client lives or where the judge was.
Right.
Because if it's where the judge was, I've got to get it admitted to federal court in Indiana because that's where the appeal would be.
Right.
For the Southern District of Indiana. Now, and I can do that. You can be admitted to federal court even if for a state, even if you're not licensed in that state.
Okay. Because again, the federal system is its own
federal system. As long as I'm licensed and as I understand it, as long as I am licensed and in good standing in any one state, then I can potentially get licensed before the federal court in any state, in any district, basically.
Okay, that makes sense.
Yeah.
So bringing it back to the client standpoint, there's a lot that's going to happen before you actually get to this hearing in Social Security. And we've talked about this before. You're going to have your first application, probably going to get denied. Most of them are. You're going to have your second application, which sometimes you'll get involved with, usually at the second application.
Correct.
And then there's a number of appeals before you, or there's other things that are going to happen, gathering medical records, all this other stuff,
right,
before you actually get to a hearing. But
yes.
But your hearing is actually your day in court. And here we're talking literally, but I mean, it's your time to get before the judge,
yes,
and be able to, answer questions that the judge may have.
Correct. It's your time to explain to the judge how your medical conditions affect you. Your medical records will document your medical conditions. They'll document your complaints to some extent. If sitting aggravates the pain and you've told the doctor that should appear in the records. And so you've got those things that the judge has in the medical records themselves. But what the medical records do not talk about is, as a general rule anyway, is how long you can sit before you start having pain, how long you can stand before you start having pain, what type of activities you can still do around the home, how you've had to change the way you do things around the home. Frequently, I have clients who still do things. They still try to be as active as they can be and do what they can around the home, but they may still vacuum, but they can only vacuum one room or two rooms, and then they've got to rest for 30 minutes or 45 minutes to let their pain calm down. They got to get reclined or lay down for that length of time before they can get up and do something else. Well, that kind of detail is never in the medical records.
Right.
And the judge isn't going to know that until you tell them that at the final hearing. That's one of the things I tell my clients when I'm preparing them for the final hearing, is that if the way you do things has changed because of your problems, you need to tell the judge that. So if I ask you, can you vacuum? And if you just say yes, the judge is going to assume you can vacuum the way you've always vacuumed. The only way the judge is going to know you have any difficulties doing that is if you tell him. So when I ask that, don't just say yes. It's yes, but this is how I have to do it now.
Right.
And then, and it's the same with any activity. The judges don't expect the claimants to be invalids and bedridden. They know they're not from that standpoint, and Social Security, the Social Security regulations do not require that to be found disabled. There's various requirements to be found disabled, but being an invalid is not one of those, or being bedridden is not one of those. And so that's your chance. That hearing is your chance to explain to the judge all of these difficulties that you have. And one of the things your attorney should be doing for you, if you have an attorney, and if you don't, you should get one, is making sure that they're asking you the questions so that the judge hears all the difficulties that you're having.
Right. That makes sense. And Jeff, you've said in a previous episode, one of the things about appearing in person at your hearing is that the judge can kind of watch. He can watch how you're walking in the room, how you're sitting there. You may have to be shifting in your seat because your lower back is hurting or some other issue. Maybe you're out of breath after a little bit. That's not something you normally can get on a phone call. That's not something you may actually pick up on a video call, but in person, the judge is sitting there watching it real time.
Exactly. So much communication is nonverbal.
Yeah.
And you're not getting any nonverbal over a phone call. In a video conference, you get a little bit, but nowhere near as much as you get in person, because most of the time when you're on a video conference, it's basically chest up is what's on the screen. So if you're wiggling around down below, the judge may see some movement, but he ain't realizing what's going on. If you have to stand, then the judge realizes you had to stand there, but still it's more, if there's some facial grimacing, that may not be seen as well because you're looking at a small screen instead of the individual. At one of the hearings I had within the last couple of weeks, the client it has problems sitting for prolonged periods of time because of their pain, and the client had to stand during the hearing, and the judge had already told her when we were talking, and she said she had difficulty sitting. He'd already told her, if you need to stand, go ahead and stand.
Yeah.
You don't need my permission to do so. And a little bit later, she did have to stand after she had squirmed in the chair for a little bit, which I had noticed and the judge had noticed. And then she had to stand. And normally I'm the one who does this, the judge himself, which I appreciated. But the judge made note of it, and he said, well, let the record reflect, because the recording of the hearing is audio recording. So there's not a video of that. And so the audio would not pick up the person standing. And the judge said, let the record reflect that 12:09 p.m. Miss so-and-so stood. And frequently I do that when my client stands, but the judge beat me to it in that situation. But the fact that the judge did beat me to it made a mental note that the judge, that's something that's important to this judge, is to know my client has difficulty sitting and has to stand. And I think it was at least partially the reason that my client's presentation at the hearing, I'm comfortable, is part of the reason why we were successful in that case.
Yeah. Well, and also if something were to go up on appeal, it's nice to have that documented in the case record, I would say.
Yes. Yeah. The attorney should be, if the claimant has to stand, if the judge doesn't do that. And like I said, that's the first time I've ever had a judge do that I can recall. But normally I'm the one who says that. I may not state what the time was because there's not a camera or a clock right in front of me as a general rule, but I'll say just let the record reflect that my client has stood up, and we can figure out what time we need to. And when client sits back down, a lot of times I'll say, let the record reflect my client sit back down. And so, that makes a difference when the judge sees that, or they see them wiggling in the seat because of the pain that they're having, or walking into the room. If it's a person who's got a problem with their gait, one client I had a drop foot. Because of some nerve damage they had, and has great difficulty walking, but also has difficulty sitting and walking into the room. The judge seen him walk into the room, and then him having to stand and seeing the difficulty he had standing and sitting back down. And is a fairly young individual, and the judge used that as one of the vocational expert in that case had offered that with the set of restrictions that the judge had given to the vocational expert, that there were jobs there, one of which was that the person, one of the restrictions was the person had to change positions from sitting to standing every 15 to 20 minutes. And surprisingly, the vocational expert said there's work available that allowed that. I don't think there is, and I planned on cross-examining him thoroughly on that. But then the judge added in that, okay, let's, as we've observed Mr. So-and-so here today, it takes him a minute or two to stand, and it takes him a minute or two to sit back down when they are, because of their difficulties moving around. And the vocational expert would said with that restriction, that would take away all jobs if we're going to be off task for 2 or 3 minutes each time they have to change every 15 minutes. And said, no employer is going to accommodate that. And the judge, well, I think that's the appropriate restriction. And so, and let me know that he's going to grant it, so I didn't have to cross-examine the vocational expert in that situation.
And after all, this is a disability hearing.
Correct.
I mean, that's what we're trying to determine. So
that's what we're trying to determine. But the presentation of the client at that hearing, and the judge seeing the difficulties, was a huge factor in that case being successful. And I don't think the judge would have seen the client standing and sitting if we're on a video conference hearing, but he wouldn't have seen the difficulties, as much of the difficulties as the client had doing that.
Well, a picture's worth 1,000 words, and this is a live picture at that point.
Yeah.
We've also had a previous episode where your client and his spouse came in.
Correct.
And talked about, hey, we had representation, or at least we were filing a case, and they did not want to go with them to a in-person hearing. And they consulted with you, and they ended up ultimately firing that company and hiring you to represent them. And I guess the case turned out fairly well because of that.
Correct. And yeah, that was one. They had come in to talk to me. A friend of theirs had referred them to me. They had a company, one of the national companies. I don't know if they were attorneys or not. I'm not sure about that.
But again, Social Security disability allows that to happen. That's there are representatives out there that can help you with your case up to a point.
Correct. Exactly. Yeah. They can handle it at the administrative level. They cannot go to federal court with you, which is one of the problems with using those type of companies. But this company may have attorneys. I have no idea in that regard, but they came in and they weren't happy with that company. When one of the reasons they weren't happy is they had told the company that they wanted to go in person to their hearing, and the company did not do that.
Wow.
They didn't put it in to be an in-person hearing. And the hearing, I think, was actually, I don't know if it's quite set at that point, but it was going to be set soon. And they come in to talk to me, and I said, well, it's your choice on if you want to stay with them or come to me, but I would strongly encourage you to do an in-person hearing in it, and that company wasn't going to change it, apparently. And luckily, the judge in that case allowed us to withdraw consent to a video conference hearing and do an in-person hearing. Yep. And I think that was one that being in person made the ultimate difference in the case being granted. It may have been granted without the in-person hearing, but I think it sealed it to the judge that, this is a case that needs to be granted. This person's not going to be capable of holding down a job.
So let's come back. Kind of the core topic here is the fact that, without the judges being readily available, and now maybe no longer in Paducah, they may be going to Evansville or somewhere else, based on the personnel. Are they going to replace some of these judges? Do you have any information about that? I mean, does this problem get better, or is this kind of what we're stuck with for now?
I think they're going to at least do some limited replacement. There's been a hiring freeze on at the federal level, I believe, for a while, at least in the administration. I think at other agencies as well. And what's happened is you've Paducah judges where they'd been there for a lot of those had been with the administration for several years. They were retirement level, and they've retired and then not replaced. Judges can transfer as well. So it could be that someone somewhere else wants to come to Paducah. And so that may be what occurs. So they may get someone who does come to Paducah from that. One of the judges I had in Evansville, I can't remember where he said that he was from southern Indiana, and he was looking to come to, he took whatever the first opening was to get on. He'd worked with the administration as a staff attorney, and openings come up, and he put in and he was hired, but he had to go wherever there was an opening.
Right.
And that's what he did. And then he put in to transfer to Paducah. And while that was pending, Evansville slot opened at Evansville, so he switched to go to Evansville because that's where he would prefer to have been from there. So you may have somebody who is at some other hearing office somewhere else that wants to come to Paducah. So and I hope we do. I hope we have. As long as you're a good one. So I think it will. I think they will at least get somebody in Paducah. And this judge said that he thinks, because I don't think Paducah is the only hearing site that's having this issue right now, that he thinks they're going to authorize them to at least have a limited hiring of some administrative law judges. So
So you've got all of these cases coming through the system. You've got fewer and fewer judges there to take the case and to deal with the hearing. What does that do to the client's case and from a time frame standpoint?
I think they're still trying to move them through fairly promptly.
And that's in government terms.
In government terms, yes. I'm probably seeing, I think we're seeing about 9 months to a year from the time we filed the request for hearing before we had these hearings in these cases.
And again, you've got a lot of steps that happen before that.
You got a lot of steps that. Oh yeah. You're a year and a half from the initial application, probably in that regard. So there's times processes that come into play. Some initial denials take usually about 3 months. Some take 6 months or longer, and that all delays everything else. But so you've got a significant time invested in the case. The attorney has significant time invested. The claimant's got significant time invested in the claim as well. And it's difficult for the claimants when it takes that long because they're not able to work. They don't have money. A lot of people don't have short-term or long-term disability, so they don't have any money coming in. And it can, they're begging and borrowing from friends and family to make ends meet until they can finally have their day in court.
Yeah. Well, I mean, I hope that gets resolved.
Yeah.
Jeff, we're here in Callaway County. We're at your Murray office, but you've also got an office in Hopkinsville in Christian County, right?
I do. Yeah, I've got an office on South Virginia Street in Hopkinsville. I've had that office for a couple years now. Been in Murray for a long time, but always, as I've mentioned before, I've always had a lot of clients up in the Hopkinsville area, Christian County area, and so I opened that office up there to be able to better serve the clients up in that area.
That makes sense. Now, good news is you've got one phone number regardless of which office they're trying to meet you at, right?
Correct. Yes. Phone number is 270-753-0053. Call that number. It rings to my office and someone that's on staff with me, not a call center, not an answering service. Someone here will answer the phone if it's during regular business hours, unless we're tied up on other lines from that standpoint. But you get a live person that talks to you. And if you're not a current client, then they'll get whoever answers the phone will get some information from you, find out what type of case you're calling about, get some information from me, look at it, and then we'll see what we can do to help people out.
Okay, outstanding. So Jeff, you handle, in addition to Social Security disability, you handle a lot of workman's compensation claims. You do a lot of those. You also do a lot of personal injury. So this is car wrecks, this is motorcycle accidents, trucking collisions.
Correct. Yeah, I do a lot of car wreck cases, a lot of motorcycle wrecks, truck collisions, premises liability. From that, any type of personal injury case.
Even dog bite claims.
Yeah, any type of personal injury claim I can handle in that regard and have handled pretty much every one of them in some form or fashion during my career there. And so a lot of attorneys at least dabble in personal injury. That's all I do. My practice is personal injury practice. I do workers' comp, Social Security. Not a lot of attorneys do that there, but and very few dabble in workers' comp or Social Security just because it gets you in trouble.
Yeah. Well, it's a different system.
It's a different system. It's a different system. And if you don't know that system, you can do damage to your clients from that standpoint. But as we talked about before, there are times that the client has the personal injury claim because they were injured in a car wreck while on the job, so they got a workers' comp claim, and unfortunately, sometimes even a Social Security disability claim, and you can have one law firm that's handling all three of those claims.
Right, which also helps because the coordination, obviously, it's you.
Correct.
So you kind of understand the timelines, you understand what's been done, and you're not worried about, well, I didn't know your case had changed because you're handling it.
Correct, exactly. Plus, it tends to cut down on the cost because the medical records I need for the car wreck case I can use in the workers' comp case and the Social Security case. If you have three different attorneys are getting records, paying for records, and now you're paying for the same records three times.
Yeah.
If they're not coordinating. Now, they should be coordinating. If you have different attorneys, they should be coordinating and sharing records.
That's a real good point. In a previous episode, you did bring up the fact that if let's say you've been in a car wreck, but yet you're also trying to get Social Security disability.
Right.
You need to make sure both of your attorneys understand you've got the other claim going as well, correct? Because you can file them at the same time.
You can file them at the same time, pursue them at the same time from that standpoint. And if you've got two different cases going over the same injury, you need to make sure, if you got two different attorneys handling that, you need to make sure that they are aware of each other. I've got some attorneys who don't do workers' comp or don't do Social Security disability that will reach out to me to handle that part of the case there, and then we coordinate back and forth in that regard. If you've got a workers' comp claim and a Social Security disability claim, you definitely need to make sure your attorneys are coordinating with each other, because that can make a big difference on what you're getting in one or the other from that standpoint, because of some of the Social Security laws there. But the same with car wrecks and workers' comp and car wrecks and Social Security. So if you've got different attorneys handling the different claims, make sure they each know the other's handling the claim, and that they know that they are working together from that standpoint, and sharing not sharing the medical and the other information, because I may get something in the workers' comp claim that's very helpful in the car wreck case that somebody else may be handling, or product liability case, or whatever it is from that perspective. So you can you can do yourself a disservice if you don't let the attorneys know, because I can't call Joe Blow attorney up and say, "Oh, I'm representing client X in this case. Are you representing them in another case?" He or she can't tell me who their client is. I can't share that information unless my client gives me authority to do that.
And that's attorney-client privilege. That's why they can't. You literally can't, based on the laws.
Yeah, ethically, I cannot. I'll have people. Ethically, I'm not allowed to share client information unless it's advancing the client's case, or I have express authority from my client. So if somebody calls me up, and I'll have, it's occur at times, they'll call me up and say, I'm mother or cousin or aunt or friend or whatever, are you representing so and so in a claim? And it's like, I can't confirm nor deny that. I can't share that information with you. The only time I can tell you if I'm representing someone is if they give me authority to do that.
Right.
And sometimes it's like a landlord and they're behind on rent and they want to confirm it, and then client will call me up and say, "You can confirm that you're doing this for the landlord." Right. There's times that I get authority to do that because it benefits the client, but I don't do that unless I've got express permission from the client.
But once again, coming back to it, the fact is you can handle all three claims. They can happen at the same time anyway, and the communication issues obviously are not there because you're handling.
I talk to myself all the time.
Fantastic. Well, Jeff, I really appreciate your time. We do a lot of these podcasts. We try to take complex legal issues and kind of simplify them, because they are complicated, and sometimes you get mixed up and you're not quite sure what to do. And hopefully you've got a library now of podcast episodes that you can go back to, and you can look at, okay, yeah, that came up. I didn't fully understand that. Now I can go listen to a podcast about it. We put together a bunch of show notes with each episode. So usually there are links to related episodes, so that if you've heard something, you might be able to link to it instead of you having to go through, over 100 podcast episodes. You can actually click that link and it'll go right to the one that you're most interested in. So hopefully that'll be helpful to you. But, definitely check out jeffrobertslaw.com. We've got all of the episodes there. You can find them on Spotify, iHeartRadio, Apple Podcast, really everywhere. So, Jeff, once again, thanks for your time and your diligence on this. And thanks for making this information at least more understandable for the average person out there.
Well, thank you for all the work you do on these podcasts. I appreciate it.
Absolutely. We'll be back in a couple of weeks. Take care. Bye-bye.
Thank you.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.